Hello students, my name is Abhishek Sudhir and I am an assistant professor at the Jindal Global Law School. Welcome to the EPG Pathshala on Civil and Political Rights and module number 20, the right to privacy in India. Much like in the United States and the United Kingdom, there is no explicit constitutional right of privacy in India. Thus, the development of the right to privacy has fallen to the judiciary, and the Supreme Court has gladly accepted this responsibility. This module will chart how the right to privacy has been read into Article 21 of the Constitution. The module will then focus on the components of the right to privacy, which have been expanded by judicial interpretation to cover cases of telephone tapping, among other things. Attention will also be paid to the interrelationship between the right to privacy and the freedom of the press in India. The purpose of this module is twofold. First, to give the students an overview of the constitutionally recognized components of an individual's right to a fair trial. And second, to help the students understand the manner in which the scope of the right to a fair trial has been expanded by judicial interpretation. Let's start with Article 21 and the right to privacy. The meaning of the word life and expression personal liberty in Article 21 has been elaborately considered by the Supreme Court. Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. In Kharak Singh's case, the court considered the validity of police regulations that authorized police personnel to maintain lists of history sheeters being repeat offenders, in addition to conducting surveillance activities, domiciliary visits, and periodic inquiries about such persons. The intention was to monitor persons suspected of or charged with offenses in the past with the aim of preventing criminal acts in the future. At the time, there was no statutory basis for these regulations, and they had been framed in the exercise by the state of administrative functions. This is the regulations were formed when India had just got independence, basically. The majority opinion in Kharak Singh's case was delivered by Justice Iyengar. Justice Iyengar held that these regulations, administrative regulations authorizing surveillance activities on history sheeters, did not violate personal liberty, except for those which permitted domiciliary visits. The other restraints, such as surveillance activities and periodic inquiries about history sheeters, were justified, according to Justice Iyengar. He observed at para 20 of the judgment that the right of privacy is not guaranteed under our constitution, and therefore the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not an infringement of a fundamental right guaranteed by Part 3. It was very, very simple. In Kharak Singh, basically, they said that there is no right to privacy in India. Therefore, it's fine. The surveillance activities are permissible. However, the minority in Kharak Singh read the right to privacy as being part of the right to life under Article 21 of the Constitution. Essentially, the minority was saying, what kind of life can one be expected to lead if you cannot have a private life? You don't have the right to privacy in that life. In doing so, the minority relied on a quote from American Judge Felix Frankfurter's judgment, and I quote, "The security of one's privacy against arbitrary intrusion by the police is basic to a free society. It is therefore implicit in the concept of ordered liberty," unquote. In the same case, Justice Murphy considered that such invasion of privacy was against the very essence of a scheme of ordered liberty. In Justice Subbarau's powerful dissent in Kharak Singh, he held that it is an essential ingredient of personal liberty, and the right to personal liberty is a right of an individual to be free from restrictions or encroachments on his person, whether those restrictions or encroachments are directly imposed or indirectly brought about by calculated measures. Said liberty means privacy. How can you have personal liberty if you do not have privacy? Was what Justice Subbarau was saying. The minority acknowledged that the right to privacy by itself had not been identified under the Constitution. As a concept, it may be too broad and moralistic to define it judicially, was what Justice Subbarau said. Whether the right to privacy can be claimed or has been infringed in a given case, according to Justice Subbarau, would depend on the facts of the said case. So essentially, the minority said there is a right to privacy, not explicit, of course, but implicit in the wording used in Article 21, which is personal liberty. Here, you're looking at a picture of the former Chief Justice of India, Subbarau, who generally wrote a lot of dissenting opinions during his time on the bench. Now we come to the landmark case of Gobind versus State of Madhya Pradesh. Kharak Singh's case was considered by Justice Matthew in this classic judgment, and the origin of the right to privacy was traced comprehensively by the great judge. In Gobind versus State of Madhya Pradesh, the Supreme Court approved of some police regulations that provided for surveillance activities. But this time, the decision pointed out a clear statutory basis for these regulations, right? So there was a statutory basis for the police regulations, unlike in Kharak Singh, where it was a purely administrative act. However, Justice Matthew held the right to privacy was a part of the chapter on fundamental rights. Privacy was a fundamental right, according to Justice Matthew, but it was not an absolute right. And I quote, "The right to privacy in any event will necessarily have to go through a process of case-by-case development. Therefore, even assuming that the right to personal liberty, the right to move freely throughout the territory of India, and the freedom of speech create an independent right of privacy as an emanation from them, which one can characterize as a fundamental right. We do not think that the right is absolute," is what Justice Matthew held. He made it clear in Gobind Singh that the right to privacy, of course, was by no means absolute, but was a fundamental right nevertheless under 21, and Gobind Singh essentially overruled Kharak Singh's case. Now the case of R. Rajgopal versus State of Tamil Nadu. Following the judicial expansion of the idea of personal liberty, the status of the right to privacy as a component of Article 21 has been recognized and reinforced. In Rajgopal versus State of TN, the court dealt with a fact situation where a convict intended to publish his autobiography. In that autobiography, he intended to describe the involvement of some politicians and businessmen in illegal activities. The publication of this work was challenged on grounds of invasion of privacy, among others. It was held that the right to privacy could be described as a right to be let alone, and a citizen has the right to safeguard the privacy of his family, marriage, procreation, motherhood, childbearing, and education, among others. No one can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical. However, the Supreme Court held that exceptions may be made if a person voluntarily thrusts himself into a controversy or any of these matters becomes part of public records or relates to an action of a public official concerning the discharge of his or her official duty. So once again, like in the United States, here in India, a distinction is drawn between a public figure and essentially a private citizen. And the right to privacy accordingly varies. Now coming to the case of PUCL versus Union of India. PUCL stands for the People's Union for Civil Liberties. It was held that the unauthorized tapping of telephones by police personnel violated the right to privacy as contemplated under Article 21. In PUCL versus Union of India, the court explained the rationale behind this decision as follows. The right to hold a telephone conversation in the privacy of one's home or office without interference can certainly be claimed as a right to privacy. Telephone conversation is an important facet of a man's life. Right to privacy would certainly include telephone conversation in the privacy of one's home or office. Telephone tapping would thus, in fact, come under the ambit of Article 21 unless it is permitted under the procedure established by law. So very, very simple. They did not say telephone tapping was illegal, but they said telephone tapping had to be authorized by law. If not, it was a direct violation of the right to privacy. So, basically they said no absolute bar. And why is there no absolute bar? Because the telephone tapping may be necessary in some circumstances to prevent criminal acts and in the course of investigations. Recently in the news, the phones of several ministers were tapped and created a huge controversy, right? Telephone tapping is widely misused in India, in most cases by state authorities and sometimes by even private actors. So the Supreme Court said telephone tapping is as serious a violation of right to privacy as there can be, and therefore any telephone tapping must be in accordance with the provisions of the law, basically. The court said such intrusive practices are permissible if done under proper legislative mandate, as I've just explained, that regulates their use. Any invasion of privacy, needs to be authorized by law and needs to be regulated by law, because you're invading privacy. And if the state is to invade privacy, then it needs a legislative instrument under which it has to operate, because that's how you keep a check and a balance. The intended balance between an individual's right to privacy and compelling public interest has frequently occupied judicial attention. Such a compelling public interest can be identified with the need to prevent crimes and expedite investigations or to protect public health or morality. So tapping might be necessary, as what the Supreme Court has said. And because tapping might be necessary, they have decided that there is no need for an absolute bar, and that constitutionally telephone tapping is permissible provided it is in accordance with the procedure established by law. Now we come to the rather interesting case of X versus Hospital Z. In X versus Hospital Z, it was held that a person could not invoke his right to privacy to prevent a doctor from disclosing his HIV positive status to others, right? Basically, this is a controversial area, right? HIV. In certain countries, like in Gulf countries, if you're HIV positive, they will not even let you into the country. That's not the case in India, for example, right? A person cannot invoke his right to privacy, however, to prevent a doctor from disclosing his HIV status to others was what XV Hospital Z held. However, that decision was appealed. The decision originally stated that the duty of confidentiality between the doctor and patient could be compromised in order to protect the health of other individuals. So a lower court held, right, that the High Court there held that yes, actually, you know what, this confidentiality can be compromised because you have to try and protect others. You know, HIV is a public health issue. You don't want somebody who's HIV positive to perhaps infect other persons, right? That was a pretty draconian ruling, and it was overturned. Originally, Justice Sagir Ahmed held as follows. When a patient was found to be HIV positive, its disclosure by the doctor could not be violative of either the rule of confidentiality or the patient's right of privacy, as the lady with whom the patient was likely to be married was saved in time by such disclosure, or else she too would have been infected with the dreadful disease if marriage had taken place and been consummated. So the court held that, look, you cannot disclose the status no matter what. You can only disclose the status actually, right, when disclosure of the status would lead to the protection of public health of others. This decision is suspect. I mean, there is a conflict. Yes, what is the conflict? The conflict is between the right to privacy of a person suspected of HIV not to submit himself forcibly for medical examination, and the power and duty of the state to identify HIV infected persons for the purpose of stopping further transmission of the virus. Now, it's all well and good telling a woman, let us say a man is diagnosed as HIV positive, his fiancée is with him, and the doctor discloses his HIV positive status to her. The rationale there is, yes, I have violated patient-doctor privilege because I want to protect the health, or I want to protect this woman from marrying somebody who's HIV positive. And if they get married, of course, the virus will be transmitted when they have intercourse. Now, is that an issue of public health, or is that an issue of just one individual's life? Right? The court, according to Justice Sagir Ahmed, has gone for the latter interpretation and said that's a public health issue. So does that mean that the state tomorrow can start naming and shaming HIV positive patients? That's the question. Probably not. But in the limited scope, in a limited sphere of X versus Hospital Z, they said in disclosing the status to a woman he is about to marry because it would save her from being infected with a dreadful disease was absolutely constitutional, right? So the conflict between privacy and public health, right? In the interest of the general public, it is necessary for the state to identify HIV positive cases, and any action taken in that regard cannot be termed as unconstitutional, was what the court said, as under Article 47 of the Constitution, the state was under an obligation to take all steps for the improvement of public health. A law designed to achieve this object, if fair and reasonable, right? It has to be fair and reasonable, in our opinion, will not be in breach of Article 21 of the Constitution of India. So the court again restricts it, right? They say, okay, it has to be fair and reasonable. That law has to be very fair and reasonable. You cannot pass a law tomorrow which mandates that any doctor who becomes aware of an individual's HIV positive status must carry out an advertisement in the newspaper stating that this person of so-and-so with this address is HIV positive. That law would not be fair and reasonable, right? There are much more restrictive ways of actually containing it and improving public health when you find out that somebody is HIV positive. Now, we come to the famous case of Selvi versus State of Karnataka, which was decided in 2011 by the Supreme Court. Known as the narco analysis case, the Supreme Court stated in Selvi that a distinction must be made between the character of restraints placed on the right to privacy, right? How are you restraining someone's privacy? There are different types of restraints, right? At a fundamental sort of first principle level, there are two ways you can restrict privacy. The first way is actual physical restriction of privacy, right? So, ordinary exercise of police powers contemplates restraints of physical nature, such as the extraction of bodily substances and the use of reasonable force for subjecting a person to medical examination. Physical constraint on privacy. Yeah, physical constraint. At the end of the day, the police will do anything to make their life easier. One has to empathize with them, right? But the problem is you cannot keep on extending their power to restrain someone physically, right, to powers to forcibly extract testimonial responses, right? In conceptualizing the right to privacy, the judges in Selvi sought to highlight the distinction between privacy in a physical sense and the privacy of one's mental processes. And the standard is going to be much stricter, more stringent when you're restricting the privacy of one's mental processes. You're interfering with the way they think, you're interfering with what they can say, right? So that is a restraint on privacy that has to meet a very high standard, right? So let's look at some quotes from the judgment which will help you understand this concept better. In Selvi, Justice Balakrishnan wrote the judgment said as follows, and I quote, "So far, the judicial understanding of privacy in our country has mostly stressed on the protection of the body and physical spaces from intrusive actions by the state. While the scheme of criminal procedure, as well as evidence law, mandates interference with physical privacy through statutory provisions that enable arrest, detention, search and seizure, among others, the same cannot be the basis for compelling a person to impart personal knowledge about a relevant fact." The court went on, "It is our considered opinion that subjecting a person to the impune techniques in an involuntary manner violates the prescribed boundaries of privacy." This is the key. Involuntary and voluntary. If you voluntarily agree, right, and you say, yes, invade my privacy, invade my zone of privacy, that's permissible, provided the consent is informed consent, right? So a police officer has to tell you, we are now going to, let us say, inject you with a particular substance that will make you tell the truth. We're going to carry out a lie detector test. We're going to have a narco analysis test where you're going to go into a state of sort of a different consciousness wherein you lose the inability to lie. Whatever your deepest, darkest, underlying secrets in your mind will all come out, right? Now, the police cannot do that forcibly, is what Selvi said. The person either consents, and that consent has to be fully informed consent, right? A well-informed consent, right? It has to be free and fair, free consent, okay? No duress, no pressure, right? This court has said forcible interference with a person's mental processes is not provided for under any statute, and it must necessarily come into conflict with the right against self-incrimination, right? So essentially, under the Constitution of India, Article 20, you have the right not to incriminate, right? You have the right not to incriminate yourself. You have the right not to be forced to be a witness, right? You have the right not to be forced to be a witness against yourself, right? So essentially, if the police forcibly interfere with the mental processes, inject you with a truth serum, carry out a lie detector test, etc., without your consent, and they do it forcibly, they are violating not only your right to privacy, but also your right against self-incrimination. Now let's come to the interesting case of black money. In the case of Ram Jethmalani versus Union of India, the Supreme Court held that the revelation of details of bank accounts of individuals without establishment of a prima facie case to accuse them of wrongdoing would be a violation of their right to privacy. This is an issue that has captured the national imagination and was a major issue in the recently concluded general elections. The Prime Minister has also made an explicit promise that he will bring back black money stashed abroad. Ram Jethmalani has been a crusader in this fight and has approached the Supreme Court and continues this fight to this very day. However, in a blow to Mr. Jethmalani, the Supreme Court has held that the revelation of details of bank accounts of individuals can only be disclosed if there is a case that, yes, they have actually committed some wrongdoing. For example, personally, there are many individuals who have accounts in foreign countries. Perhaps they've gone there to study and opened an account. Should those details be disclosed, that as an Indian citizen you have a foreign bank account? Don't you have a right to privacy over that fact? Does it mean that just because you have a foreign bank account, it should be disclosed, it should be put out in the public domain that you have a foreign bank account? And if you have a foreign bank account, does that automatically mean that you have stashed away black money? If this information was to come into the public domain, it might affect your reputation, it might affect your private life. So you have a right to privacy over your bank details, was what the Supreme Court held in that case. The Supreme Court explained the rationale for their decision as follows. Revelation of bank account details of individuals without establishment of a prima facie case to accuse them of wrongdoing would be a violation of their rights to privacy. The state cannot compel citizens to reveal or itself reveal details of their bank accounts to the public at large, either to receive benefits from the state or to facilitate investigations and prosecutions of such individuals, unless the state itself has, through properly conducted investigations within the four, through properly conducted investigations within the four corners of constitutional permissibility, basically. So what they're trying to say, right, is, it's a pretty long quote, so let's break it down. First, revelation of bank account of details of individuals without establishing a prima facie case to accuse them of wrongdoing. You can only disclose, they're not saying you can't disclose, saying you can only disclose if there are sufficient grounds to believe that the person who has a foreign bank account has black money, right, stashed away in those bank accounts. What is black money? Black money basically means money not declared to the government, money on which tax should be paid but is not being paid by that individual, and through special entities abroad or in India has routed that money to a foreign bank account, right? Most commonly we associate this with the bank accounts in Switzerland. Why Switzerland? Because Switzerland has some of the most stringent right to privacy laws in the world, and there's nothing like Swiss privacy or Swiss secrecy, as they say, right? Nobody keeps a secret better than the Swiss, and that's why their Swiss banks are notorious or famous, depending on your point of view in the world. So the Supreme Court said the state also cannot compel citizens to reveal details of their bank accounts to the public at large, right? Maybe the state can say, okay, you tell us if you have a foreign bank account. Yeah, you as a citizen can tell them, yes, I have a foreign bank account. You can't compel them to say to go out on a public platform, go to a newspaper or in a news studio and say, well, yeah, I have a foreign bank account, right? You can't compel them to do that, right? At the same time, right, the state itself cannot reveal details of the bank accounts to the public at large. And this is the issue that has been a source of great conflict. The current finance minister, Mr. Arun Jaitley, right, on the floor of parliament made this very statement and said that he was barred by the Supreme Court judgment from revealing the names of people who had bank account details. To reveal the details of these individuals, they have to first establish a case of wrongdoing on their part. How can you essentially name and shame them if they've done nothing wrong? And the finance minister was on solid footing there in not revealing those details at the time, right? Now, the Supreme Court has also said, right, that they can't do this just to facilitate investigations. That is not a good enough excuse. You can't say, okay, we will reveal these names to establish a prima facie case. No, you first establish that prima facie case. Is there a case to answer? Is there wrongdoing? Then you can reveal the details of the bank account, and that invasion of privacy is permissible, basically, right? The prosecution of such individuals, right, the state itself, right, has to conduct the investigation. The state cannot delegate that responsibility, right? They have to conduct the investigation, right? They have to keep the details secret. And once that investigation is concluded and they say, okay, now we can reveal names, which the government of the day has also done, revealed a few names now after investigations have been completed, that is permissible. That is not an invasion of privacy, is what the Supreme Court has held, basically. And that is constitutionally permissible, right? So the Supreme Court went on, and I quote, "The major problem in the matters before us has been the inaction of the state. This is so both with regard to the specific instances of Hassan Ali Khan, and the Tapurias, right? People whose names were revealed, and also with respect to the issues regarding the parallel economy and the generation of black money, etc. The failure is not of the constitutional values or of the powers available to the state. The failure has been of human agency," right? Essentially, this judgment, written in 2011, accused the government of inaction and said it is the government of the day, that has failed the people of this nation. The Constitution and its right to privacy has not failed the people of this nation. The Constitution guarantees a right to privacy, and therefore the people must respect that. The people must respect the fact that until and unless the government discharges this high burden that the Constitution places, this high standard that the Constitution places, right? You have to prove that there is some wrongdoing, then you invade their privacy. Then they lose that right to privacy by virtue of committing an offense, right? Essentially, if there's a prima facie case against you of rape, right, that you have raped somebody, you forego your right to privacy in India and your name can be revealed to the public at large, right? You have police officers who will hold a press conference and say a case has been registered under section 376 of the Indian Penal Code against Ram so and so, and that is because a prima facie case has been established. You cannot reveal the names of people you've just arrested, right? And there's absolutely, if you've arrested them, you've probably arrested them with a prima facie case. And then perhaps you're probably allowed to reveal those names. But you can, as a police, cannot hold a press conference and say, we suspect that someone say like Shashi Tharoor has murdered Sunanda Pushkar, right? You please arrest Shashi Tharoor, you prove a case against Shashi Tharoor, right? You make a case against Shashi Tharoor, show there's a prima facie case. Once there's a prima facie case, Shashi Tharoor loses that right to his identity being kept private, right? And then he's tried, and then the requirements of fair trial kick in, basically, right? The fair and free public hearing, etc., etc. So the person has to be named. But in the same context of privacy, if you look at the rape victim, right? India has stringent laws whereby the rape victim should not be named. So in that scenario, we say the perpetrator can be named, but the victim should not be named because the victim has done nothing wrong. It is the perpetrator who's accused of wrongdoing. And yes, the perpetrator, is presumed innocent until proven guilty. But that presumption of innocence is in no way displaced if it is revealed to the public that he has in fact been arrested and will be tried, basically. Right? So the presumption of innocence is not displaced. His right to privacy is protected only up until the point that he is not accused of wrongdoing. The moment you're accused of wrongdoing, that standard of a prima facie case is met, your right to privacy can be overridden, right? Essentially. So the Supreme Court has said in the case of black money, all you have to do is show wrongdoing, right? And that failure to show wrongdoing is a failure of human agency. It's not a failure of the Constitution of India and its right to privacy. Essentially, the Supreme Court said the response cannot be the promotion of vigilantism and thereby violate other constitutional values. The response has to necessarily be a more emphatic assertion of those values, both in terms of protection of an individual's right to privacy and also the protection of individuals' right to petition this court. The court said the response should be to in fact close ranks and say, yes, the right to privacy is paramount. Let the state discharge that burden. The right to privacy is paramount. We cannot get carried away with sentiment and emotion. Kala dhan, as they say, right? Bring back black money. We cannot be carried away by sentiment, right? Because that would promote vigilantism, right? The Constitution must hold under any circumstances. It is a failure of the state and the state must be held accountable, not constitutional rights being trampled upon, basically, right? And they said that the response has to be an emphatic assertion of the right to privacy. The state essentially has a duty to protect the right to privacy, is the general golden thread, basically, that runs through the Supreme Court's right to privacy jurisprudence. The Supreme Court has gone so far as to say that the notion of fundamental rights, such as the right to privacy as part of right to life, is not merely that the state is enjoined from derogating from them, right? There's not just a negative obligation, but a positive duty, a responsibility of the state to protect the right to privacy. The state must protect that right to privacy against the actions of others, even in society, even in the context of exercise of fundamental rights by those others. Let us say a civil society or organization is holding a news conference, right, and they are going to name and shame people, essentially, right? The state must in no way aid or abet them in invading right to privacy. In fact, it can go so far as to say that they have a duty to prevent the disclosure of that information. Let us say a list is obtained by a news channel of individuals Indian citizens with foreign bank accounts, against whom there is no case of wrongdoing. Should that studio be allowed to publicize those names? That's the question, right? Then you have the right to free speech of expression, which starts interacting with the right to privacy. And again, you have to do a public interest weighing, right? And if you find as a state that the right to privacy of individuals is being violated, either through executive, administrative action or through legislation, you must step in, right, and protect the right to privacy of your citizens against the actions of private actors even in society, right? And even in the context of exercise of fundamental rights, such as the right to free speech of expression by those others, the media, essentially. So students, we come to the end of this module. In conclusion, we can safely state that India's Supreme Court has recognized that the right to privacy is an integral part of the right to life, a cherished constitutional value, and it is important that human beings be allowed domains of freedom that are free of public scrutiny unless they act in an unlawful manner, right? All of us have domains of freedom. We have a private space, a private sphere, right? We can choose to make some information that is private public, but we cannot have our private information being made public by the state or by other citizens in society, right? If private actors do it, we have recourse to damages. We have recourse to actions such as the tort of defamation. If the state does it, we can file a writ petition, right, to the Supreme Court, petition the Supreme Court, and ensure the enforcement of our fundamental right to privacy. This module has charted the evolution and development of the right to privacy, as we've seen through case law. We are now in the digital age, right, and the right to privacy and the bounds of the right to privacy are ever evolving. The need for the judiciary to develop the contours of this right will become all the more acute. The time perhaps has also come for Parliament to contemplate making the right to privacy an explicit fundamental right by amending the Constitution. We've done this with the right to education, for example. But the executive is often guilty of invasion of privacy, like in any other country in the world. For example, take the United States and its famous, notorious PRISM program, where the NSA, the National Security Agency, was spying on its own citizens, right? The executive is often invading privacy, and it would appear that any such overt legislative and constitutional recognition of the right to privacy is unlikely. Therefore, it once again falls to the judiciary to act against a bulwark against executive excesses violating the right to privacy.